Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast, and hello to everybody in between. My name is Dan Balkaran. I'll be your employment lawyer for the next half an hour. I am an associate at the law firm of Samfiru, Tumarkin, called to the bar in British Columbia, Canada. And so I'm going to take your questions, and usually we've had great participation over the last 6 months. Just a sort of a primer. Before we get into that, just a couple housekeeping matters. If you need to reach us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855, if the number could just pop on the screen there, 1-855-821-5900, 821-5900. Okay, housekeeping taken care of. Now, for the last 6 months or so, 95% of the questions you guys have been asking in this forum have been in relation to vaccine terminations. So vaccine policy terminations. So I'm going to once again just sort of give a quick primer as to what that means and what's happening to a lot of you. And then I want to talk about one specific issue that I encountered recently, and then we'll start fielding your questions. So the word mandate is problematic because we use it for everything, but it's not correct. When an employer says to you, hey, employee, you have to get a vaccine pursuant to our new vaccination policy, or you're fired, that's a mandatory vaccination policy by your employer. In most cases, the employer does not have a right to force you to get a vaccine. Will say it wasn't part of your contract before, so it can't suddenly make you get vaccinated now because you never agreed to it at the time of contract formation, in which case if it will fire you, but you're entitled to severance. Okay, so that's really, and I guess the important piece of that there is your only legal right in the event of your termination is severance, and it's, the amount of your severance depends on your specific legal position. For some of you who've been employed for a long time, it can be quite substantial. It can be as much as 24 months, but your only legal right in the event of your termination is severance. And if they fire you because you didn't get a vaccine, then you have that right to severance. Okay, so what a vaccine mandate does is that's a provincial health order, most likely, or it can be an order from the federal government. But it's a government order or piece of legislation that says you must be vaccinated in order to work as an employee in a given sector. What the effect of those government mandates is number one, you lose your job automatically because you can't perform it because you're not if you refuse to get vaccinated. So you lose your job, you lose your right to severance. Your right to severance is extinguished automatically, and then the federal government, who administers EI through Service Canada, has said that you are not entitled to EI anymore, even though you've paid into it your whole working life. You can't get it if the reason why you terminated is because you refused to get vaccinated. So for a lot of you, if you don't get a vaccine and there's a government mandate, you could lose everything. You could lose your job, your right to severance, and your right to emergency EI money. Okay, so that's the difference between a mandate and a government policy. Without the mandate, you most likely are entitled to severance if you're terminated for refusing to get a vaccine. So while we're waiting for the questions to roll in here, I don't see any yet. I don't know if there's something wrong because usually there are hundreds of questions by now. While we're waiting for that to roll in, I'm going to talk about one thing that I encountered in the last week. I'm just trying to figure out if there's some technical glitch going on, because we should have many questions popping up right now, and we don't have any. So while we're waiting we're seeing if our tech people can fix that. I want to talk about, I've spoken to a lot of you who are losing your jobs because of the lack of following a vaccine policy. And I think it's really important, as soon as you get a notice from your employer saying you must be vaccinated, or else, else could be unpaid leave, or it could be, eventual termination. Right there, you need to talk to a lawyer. Pay the money, talk to a lawyer, and find out what your legal position is. Because I'm talking to a lot of you who will, take a bunch of actions first, detrimental to your legal position, and then call a lawyer afterwards, after they've been fired, after they've taken those detrimental actions, and hope the lawyer can clean it up, right? And we can't always in that case, So in particular, I want to talk about something called notice of liability. Notice of liability, I'm not overly familiar with it, but it seems to be where, and it's going around, it's going around certain sectors of society, will say, where if you don't want to get a vaccine, you issue a notice of liability to your employer. And essentially what it is a threat to sue the employer if you have an adverse reaction and your health is affected by the vaccine. Okay, so first of all, the notice of liability is nothing. It doesn't do anything positive anyway. Your employer is not liable to you if it says to you, in order to continue working here, you must be vaccinated. You don't have a right to be at that job. And if the employer terminates you, you do have a right to severance, most likely. Okay. So the notice of liability is nothing in terms of a positive. What it is, in my opinion, is possibly detrimental. You're threatening to sue your employer. Okay? How can your employment relationship continue if you're threatening to sue your employer? So I mean, different lawyers have different minds about this, but I don't think any good can come of it. So before you start issuing notices of liability to your employer, or refusing to wear masks, or refusing to take rapid testing as a compromise to getting the vaccines, as an accommodation to getting the vaccines, talk to a lawyer first. It's worth it. Speak to a lawyer. You can reach us, help@employmentlawyer.ca, 1-855-821-5900. Okay, that was my brief intro. I'm just going to field your questions now. We've got a couple coming in. Brenda, what if you work for a trade and the site locations will not allow you to work unless you're vaccinated? The employer has nowhere to send us. Can they let us go? Well, so Brenda, they can let you go whenever they want. They just have to pay you severance. And so the question that you're really asking is your employment frustrated because the customer's frustration is a legal term, which means that all obligations under the contract, including your right to severance, are extinguished because through no fault of anyone's, because of some third-party event. So a classic example would be you work in a factory burns to the ground, or employee has a debilitating illness that lasts longer than 2 years, 2 to 3 years, and there's no possibility of them returning in a timely manner. That would be, all obligations under the contract are frustrated. Similarly, if an order of the government shutting down a particular business due to COVID were to occur, so if you worked for Rogers Arena, and then Rogers Arena wasn't permitted to open for a year and a half, or a casino, same thing, then arguably it's been frustrated because no one can work in that sector by order of the government. But your question is actually just an economic one. Your employer has a bunch of different customers, and those customers have vaccine policies, so your employer can't send you to any of those job sites. That to me is not in the realm of it's impossible to employ you. It's in the realm of things are economically more difficult for the employer, and I don't think it'd be. To answer your question, I think they can't fire you they can't say that your employment was frustrated and therefore they could fire you, and they will fire you, but they'd have to pay you severance, and your severance would be tailored to your legal position. And to find out what that is, certainly you should talk to a lawyer. Again, you can reach us at help@employmentlawyer.ca, 1-855-821-5900. Okay, Mark, if an employer pushed an employee to get vaccinated and they complied, what would you suggest to an employee who now requests a retention bonus? Well, so Mark, there are two ways to get stuff out of an employer. Okay, one is through goodwill, and the other is through leverage, through putting a legal gun to their head, right? So leverage just simply being, if you don't do this, I'm going to force you to do it, and it's going to be even more expensive for you because you're going to have to hire lawyers and go through the court system, and therefore you should just give me this now, right? So that's sort of how lawyers work after someone's been terminated, for example. That's how lawyers are able to get substantial multiples in terms of severance than someone would be able to get on their own, because they represent the threat of future financial pain. In terms of what you're talking about, if you're, if you complied and you got vaccinated and you're still there, if you want some sort of raise or bonus for doing that, that's entirely goodwill. That's just a negotiation between you and your employer, and it's at whatever number that you think is reasonable and that the employer will bear. I mean, I think the hard part for you, Mark, is that the entire workforce is getting vaccinated. So how is it that you, out of the entire workforce, should get some sort of bonus for doing what the rest of the workforce did without a bonus? I mean, that's just a negotiation between you and your employer. If you had been discussed with your employer ahead of time that you were not going to get the vaccine, you didn't want to get the vaccine, and this is a substantial concession on your part, maybe they'd be open to giving you something, but that would have been something that you should have agreed to ahead of time, like a conditional, like, I will do this on condition that you do this, and it probably would have been something, or that you pay me this bonus, and it's probably something you would have wanted to do in writing. So I can't help you with the amount, Mark. I can only tell you that you have to be careful. Like, the employer-employee relationship is traditionally modeled off of the old Victorian concept of master and servant. And what that really means is you don't have any power as against your employer. Your only power, that's really actually the whole purpose of employment law. It's to offset the massive power imbalance between the employer and the employee, while still giving effect to the intentions of the parties, because you don't have any power against your employer. Your employer can fire you at any time. So your only real leverage, a substantial portion of your leverage when you're talking about things that aren't legal entitlements. So in your case, this idea about the retention bonus, your leverage is the fact that you could walk away, right? And so right now we're in a super tight employment market. Particularly with skilled labor, there's a huge absence of it, and so wages are going up substantially, and the threat of walking away is a real one, right? So if you're an employee wanting to get more for himself or herself at the moment, now's the time, I guess. But you have to remember that employers are often emotional animals, and if you push them too hard, or they perceive you're being too greedy, they may have you walk away. And for some of you, they might ask you to leave, fire you. And for some of you, losing your job, as I always say, could be, for some of you, a catastrophe. If you're 53 making $85,000 a year with no university education, you can't lose your job. You got to keep that job. So, to finally answer your question, look at what your individual position is, and then make your call in terms of what you're asking for. But just remember, when you're asking an employer for money, they're not always pleased about it. So tailor yourself accordingly, your request accordingly to what you think that they will be willing to hear and bear. Okay. All right, Jordan, if you find new employment shortly after being let go by a previous employer that has comparable earnings, are you still owed severance? This is a great question. So, excuse me, Jordan. So the purpose of severance is to tide you over until you get your next job. It's not a windfall. It's bridge money to get you from here to the next job that pays you the same. And so what that means is it's if you have a right to severance, which is calculated, if you have common law severance, it's calculated to assessed pursuant to a formula. And let's just say it's 6 months. Okay, 6 months at your old wage. And then let's just say 1 month in, you find a new job that pays you the same. Okay, you still have that 6 month period, but it's the money you earn from the new job is dollar for dollar deducted from the 6 month period. So if you work in that job for 5 months, your 6 months of severance shrinks down to 1 month. Okay, so the effect of finding a new job and starting a new job is devastating on your severance entitlement if you are talking about common law severance. If you're talking about Employment Standards Act severance, you're entitled to that at law. So, and that's roughly 1 week per year of service, and you get that automatically. Okay, so I was not offered. I don't know what this person's name is. Called Z. I was not offered an alternative to testing. I was put on unpaid leave. So I think what you're saying is you were asked to get vaccinated. You were told you have to get vaccinated. You were not provided with the alternative of testing. You were just put on unpaid leave. You asked for shifts at other sites for the unvaccinated, but it was temporary. I was let go of. Can I sue for constructive dismissal? So what I said at the beginning was your only legal right in the event of your termination is severance. Okay, so if you quit, you get nothing, or if you were terminated for just cause, you get nothing. Just cause is like a legally justifiable reason to give you zero. So that would be, punch your boss in the face, you come into work high on drugs, you commit fraud, theft, that kind of stuff, or your class 3 written warnings and you're out. But otherwise, for most of you, if you're let go without cause, you have an entitlement to severance, which again is calculated pursuant to what your legal position is. Okay. Constructive dismissal is just another way to get to termination so that you have a right to severance. What constructive dismissal means is that the actions of the employer were tantamount to a termination, and therefore you treat them as a termination, and the law sees it as a termination. So classic example is if your wage is lowered by more than 10%. So if it's not, you're no longer laboring under the contract of employment that you had agreed to. They can't just unilaterally cut your pay by 50%. Obviously, that's a termination. So when you're talking about you were let go, and can you sue for constructive dismissal? If you were explicitly terminated, you don't need to sue for constructive dismissal because that's just a weaker way to get to termination. However, if you were not, and you were put on unpaid leave, the core of your contract of employment, even if you don't have a written employment contract, the core of your contract of employment is that you go to work for a certain amount of hours to do a certain amount of duties in exchange for a certain amount of pay on an indefinite basis. Okay. And under that core, for 99% of you, unless it was agreed to in the employment contract, they can't just stop paying you unilaterally. Okay. And if they stop paying you unilaterally, that is very likely it's an interruption of your pay. It's very likely a constructive dismissal. You should, in that situation, which would trigger your right to severance, in that situation, 100% talk to an employment lawyer immediately, find out what your legal position is. Again, help at employmentlawyer.ca, 1-855-821-5900 to get a hold of us. You want to be careful, though. You want to get legal advice before you do anything, because the thing about constructive dismissal is you have to get the court, if it goes that far, but you have to get the court to buy into the fact that the actions of the employer were tantamount to a termination. If the court doesn't agree with you, you quit and you get nothing. So talk to a lawyer first. Okay, William, I've been put on unpaid leave starting January 15th for 60 days, and during their letter stated they would be watching out for provincial health experts and could end sooner if Omicron hospitalizations decreased. Other provinces are lifting. Yes, they are. They're lifting their restrictions as we speak. Can I force them to reconsider and get back ASAP 12.5 years employment with pension? So, William, absolutely 100% talk to an employment lawyer. Again, help at employmentlawyer.ca, 1-855-821-5900 is how you get a hold of us. So building on what I was saying to the last person, I was saying to Z, the employer can't just suspend you, right? They have no right, most likely, depending on what's in your employment contract, but for 99% of you, they have no right to just stop paying you. By stopping paying you, that is a constructive termination of your employment. Now, there is, usually you have, what your employer's done is it's fundamentally changed it's unilaterally changed the fundamental term of your employment, i.e. paying you, contrary to your agreement, which you're objecting to. And so that's a constructive dismissal if you object to it and you say, hey, no, I don't agree with this, triggering your severance. But historically you have, or at law, you have a couple, 2 to 3 months, at least 3 in BC, but 2 generally, to say, no, I object to this, pay me my severance, before you're deemed to have accepted the change. Now, it's a little bit different with a suspension of pay, because your job is effectively over, although they are making the right noises about saying we're going to bring you back. so I mean, you could talk to a lawyer right away, and you can trigger your constructive dismissal, and you can go after severance, or you could see if they bring you back, and they might bring you back, or they might terminate you. We just don't know. I have several cases like this right now. My concern with just letting it go on, the unpaid leave go on, is that you lose control insofar as your unpaid leave might go on indefinitely. They might leave you on that thing for a year, and then at what point can you trigger your? I mean, at some point that's a termination, but there is that law that I talked about, which says you've got 2 months to trigger your constructive dismissal in the case of a unilateral change. Talk to a lawyer, find out. Lawyer will look at your specific legal position and see if it's a better bet for you strategically to trigger your constructive dismissal or wait. It also depends on you, right? You're there for 12 and a half years. Maybe you want this job. Maybe you need this job. Maybe you like this job a lot. Maybe you should wait it out, right? Like you're not wrong. There's a sea change going on right now across the provinces. It hasn't hit BC yet. In BC, we've changed some restrictions, but we haven't gotten rid of mandatory passports, vaccine passports. But Ontario certainly did. The Prairie provinces did. And so there seems to be a public opinion sea change happening. And so, maybe if you really rather just be in your job, it might make more sense for you just to wait it out because, but it just depends on your individual position. It depends on how much you need that job, how much you like that job, and whether you think they're going to leave you in limbo for a long time. So, William, I know that was sort of a conditional answer, but absolutely speak to an employment lawyer. You can reach us at employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Okay, moving on. Let's see here. We've got Hannah. Oh, it's a long one. Hold on a second. I know someone who started college just before the pandemic. First 2 year classes were offered online. Students were forced to be vaccinated, or this would be the end of their studies. 2 years later, the course is almost finished. What was the sense of vaccination if the course was offered online? What scientific studies support remote learners? This is a political question, I think. Or were colleges acting on behalf of the government to vaccinate as many people as possible? Who's responsible for damages? I can answer the last question. Who's responsible for damages if there was a death or post-vaccination injury? So, I'm not. I mean, this is more of a personal injury question, but you were in an involuntary agreement with, a contractual agreement with the school. You were exchanging money for tuition, and if one of the conditions was, okay, we'll give you this tuition, but you also have to get vaccinated, you can walk away from that. You don't have to go to that school. You can choose to no longer go to that school, which means if you decided to get vaccinated, then you were accepting the conditions of tuition plus vaccination in exchange for money. So I wouldn't think anything. I think that's a situation where you've got to make your decision at the time and then choose to be vaccinated or not. And depending on your own personal health choices. So, but no, I don't think you have a legal position. Z is back saying, I'm asking for my shifts back as I did not have the mandatory policy in my contract. But you were put on unpaid leave. Z, I don't understand the question. So you were put on unpaid leave. You're on unpaid leave. I don't know if they're going to give you your shifts back. 99% of you won't have. So this is an interesting point. 99% of you won't have mandatory vaccination policies in your contracts. That's why when you're terminated, you have a right to severance. But for anyone starting a new job after, say, when did the vaccines become ubiquitous? Early 2021. All of those employment contracts that you sign, or almost all of them, are going to contain vaccine policies. Now, in situations like that, so if you started in June 2021 and then you lose your job because you refuse to get vaccinated, and there's a vaccine policy in your mandatory vaccination policy in your employment contract that you freely agreed to, your right to severance is probably gone. So, notwithstanding whatever else the language is in the contract, which could limit your severance. So, you have to be aware of that. And for anyone starting new jobs who isn't vaccinated, that's the thing for people who lose their jobs because they refuse to get vaccinated, or they choose not to get vaccinated. It's a better way to say it. People who lose their jobs in that situation, it's not just that you've lost your job and you're not going to be able to get EI. It's also that your ability to get a new job is seriously impaired, because all new employers, or almost all new employers, are requiring that you be vaccinated. So, it's certainly something to think about when you make these choices about, let me rephrase that, when you are handling your negotiations with your employer. And what I've been saying for 6 months, if your employer has a mandatory vaccination policy and you want to still be there, an amicable solution is always the one you want. Okay. And that's not always possible, right? Like if you work for some huge employer like Vancouver Coastal Health, I mean, I know that most of those people are covered by a government mandate, but some probably aren't. If you work for a huge employer, there's going to be no wiggle room in the policy. But if you work for, a 100-person IT shop, technology shop, that's a closely held corporation, yeah, you might be able to say, look, hey, I like working here at ABC Company. I've loved it. I like working for you. I can't get the vaccine for these health reasons, but I don't know how long this is all going to last, but can I work remotely for the next 6 months? Then we can reevaluate. I'll reevaluate my health situation. Is there any way to make this work? And for a lot of people, they probably can. Not always, but for a lot of you, if you don't want to lose your job, or if you can't afford to lose your job, explore the amicable option. And just for everybody, talk to an employment lawyer first before you do anything. It's so complicated. You've got vaccine mandates across the country. You've got federally regulated mandates to apply to federally regulated employers. You have provincial ones, but they don't cover everybody. It's extremely complicated. You need to speak to a lawyer on this one. I just saw on the screen covidrights.ca, super helpful. It helps. It's sort of like it's a resource base for understanding, knowledge base for understanding where all the different mandates are and what the latest news is on COVID vis-a-vis your employment law rights. You can reach us. There's one more question. Let me get to that question first, then I'll wrap it up and give you all the information about how to get a hold of us. Okay, Jay asks, if you make a small financial investment into a company that you work for, giving you a small percentage of ownership, well, that just sounds like you're purchasing shares. Are your employment regulations and entitlements the same as if you never made the investment? Are the rules the same for private versus publicly traded corporations? Okay, so Jay, this happens all the time. There's a difference between you as shareholder and you as employee, right? So if you are fired, let's say, from a company that you own shares in, you still have all of your existing rights, under the common law. You'd be entitled to severance pursuant to whatever your legal position is. Okay, but if and in that situation, your ownership of the shares is not affected. You don't lose your shares if you're fired. However, there are many situations which I've seen which the purchase of the shares that are offered to you as an employee have in the contract that allows you to purchase the shares that if you lose your job, you must sell the shares at that moment at whatever the market price is, right? And that's certainly legal. So it depends on to a large degree. My first answer is your rights are not changed just because you're a shareholder, subject to whatever your shareholders' agreement was. And then are the rules the same for private and publicly traded companies? Yes, they would be. As far as I know, they would be. It's not really a question I've encountered before, but your rights as an employee are what they are at law. And just because you are also a part owner of the business, however infinitesimally small, those rights don't change. Okay, so this is the first time we've gotten through all the questions. So thank you guys all. Those were great questions. I appreciate the questions. You can, if you need to reach us, you can do so at employmentlawyer.ca, covidrights.ca, help@employmentlawyer.ca, and 1-855-821-5900. I saw on the screen that next week, I think it's next week, well, it must be next week, today's Friday, Next week, we're doing a live chat with the head and founder of our firm, Samfiru. Don't want to miss that. Lior is brilliant at employment law, and so you should all join and ask him your questions. And certainly, we look forward to that. So thank you all. I'm glad I got all your questions today. I wish you a wonderful weekend, and I'll see you personally. I'll be back in 2 weeks in this spot.